Let me just briefly introduce our moderator and tell you how the next hour is going to go. We're going to transition straight to the panel. Representative Lofgren is kind enough to stretch out her schedule with us. So when she gets up and leaves at 9:30, it's not that she's taken offense, we hope. It's just that she's got other things she's got to do. But the panel will continue on after that. Let me just briefly introduce. Ben Johnson will be moderating. He's the Executive Director of the American Immigration Council. I know him from 20 years ago as my co-founder at Immigration Outreach Center when we used to do nonprofit immigration law right around the corner from the Lettuce inside Food City in South Phoenix. He's come a long way. We also have with us, obviously, Representative Zoe Lofgren. We also have Paul Virtue, former General Counsel of INS, currently a partner at Baker McKenzie. And we have our own Tino Cuellar, who is a professor here at Stanford Law School and is the co-director of Stanford's Center for International Security and Compensation. And then finally we have, of course... Cooperation,
not compensation.
Sorry.
Although if you have anything to say about compensation, I'm happy to.
Sorry about that. Can you tell I do corporate governance too much? Anything that starts with a CO, I say compensation. Tino needs to say cooperation. And also we have, and we're fortunate to have with us, Doris Meissner, who is currently a Senior Fellow and Director of the Migration Policy Institute U.S. Immigration Policy Program, but she's also, of course, the former Commissioner of the U.S. INS from 1993 to 2000. Each of our speakers today bios will be online in the virtual link that if you haven't gotten it by email, you will receive it. Also, lots of materials related to their discussions will be available there as well. I just don't want to take too much time introducing them further, and I'll hand it over to Ben Johnson. Thank you.
Quick summary of that introduction was 4 really smart people and a guy who worked in the lettuce department. Is that how that worked? All right. Fair enough, actually. So I'm, Ms. Lofgren, I want to start with you, and since I get to be moderator, I'm going to resist the temptation to completely jump into the process question, but I do want to think a little bit about how we, from a process perspective, how we get from here to over the finish line. But I'm interested in your sense of, this Senate bill introduced, and maybe we can get a little bit more into the weeds. But even at the top line, given the change in attitudes that you talked about, is this bill where you think you would have expected it to be in terms of overall, in terms of its content? Is it, in some areas it seems remarkably improved from what was introduced in 2006, 2007. Did it sort of meet your expectations of reflecting this change of political tone? And then maybe that one level down is, how does, from a process or from a policy perspective, did it get most of it right?
Well, I'm not really in a position to totally critique the Senate bill. It's not exactly what I would have written if it was just up to me, but it isn't just up to me. I mean, it's a product of a bipartisan effort. I think it certainly addresses all of the issues that the public wants addressed, from security to future flow of workers to dealing with families to dealing with the currently undocumented. I do think already some of the right-wing talk shows are taking on the bill, and Senator Rubio in particular, about the border trigger issue. And I am absolutely confident that as people go through the bill and add up the number of visas, there will be a substantial pushback from some segments. In terms of how we move forward, I know that Senator Leahy is planning to start the hearings today. They want to move quickly, but on the other hand, there are certainly senators who want to make sure that they know what they're doing and that they have thoroughly examined and amended the measure. So I'm in a position where I can't say when they will pass this. They've indicated they'd like to get it done by June. I don't know whether that's viable or not. Certainly we saw with the gun vote, it's possible for a minority to throw a wrench in the whole darn thing. So they've got to reach consensus or change their filibuster rules, which I've recommended, so that they can come to grips with this. On the House side, we have not introduced a bipartisan bill at this point. If we are able to do that, obviously, what happens next? There are many committees of jurisdiction. My personal view is that some of the jurisdictional reaches are tangential, and it is not unheard of. As a matter of fact, it's routine that committees that have only tangential jurisdiction waive jurisdiction if their views have been solicited. But certainly the Judiciary Committee has jurisdiction on 95% of it or better. The chairman of the committee, I don't think, has not embraced the bill. He has indicated that he looks forward to working on it. I think this is really a decision for the Republican leadership. If they want a bill, they're going to have to indicate the parameters of what they want. And I've served with Congressman Goodlatte for many years. He's a fine person. We work together on many things. I know where we disagree as well. He's not some rogue chairman. I mean, he's a team player. He's a good Republican. And I think that he will see his chairmanship as he's a thoughtful guy, careful guy. But I think he also sees himself as part of a team. And the question is, what do the captains of that team want?
And who else should we be listening to or looking to as sort of indicators of how this debate is progressing? I mean, I think we know the Gang of Eight and Marco Rubio clearly going to be really important voices in this. But as the process unfolds, who do you see as the folks maybe that are sitting on the fence that really are going to determine whether this is going to get it where we need to be or not?
Well, I've learned long ago never to predict what the U.S. Senate will do. So let me just talk about the House side. We've never thought of ourselves as a gang, the 8 of us that are working, but we are a bipartisan group that has been working for so many years to try and reach conclusion. I think that key to this will be the Republican leadership itself. Speaker Boehner has given positive but relatively nonspecific support for immigration reform. Mr. Cantor has been less vocal, but certainly not negative, on immigration reform. So I think really the Republican leadership is going to play a key role in whether this happens. They are going into listening groups throughout the Republican conference because, and I don't say this in criticism, most members of Congress don't know anything about immigration law. I mean, you talk to them on both sides of the aisle, and they don't know what the rules are. Well, that's fine. I couldn't tell you what the milk price support rules are either. I mean, people specialize, and so part of it is an educational process, and then part of it is the public. I think that outside individuals, whether the conservative commentators that helped sink the bill in past years are taking a different posture, will have a very big role on what happens within the institution.
And Doris, so you've seen some of these things play out before in the past and been in a position to have to implement some of the things that wound their way through Congress. Sitting here today, looking at this sort of first draft of it and the politics of how it's shaping up, what's your sense of, are we in a good position? Are we hitting the right notes not only from a political perspective, but are we hitting the right notes in terms of ending? If we get to the finish line on this, are we hitting the right notes in terms of something that's going to be workable and implementable? Will these politics meet the road in a way that will work? What's your sense of that?
Well, it certainly is the case that the way in which legislation is written can make it eminently more difficult or more possible to implement properly. And you do hope in an ideal legislative process, and I think that Congresswoman would agree with me, that there is real dialogue going on between the executive branch and the people on the Hill that are drafting, particularly in some of the more detailed measures that are not really the top line, kinds of policy choices that have to be made. And I actually think that in looking at the Senate bill to the degree that I've been able to digest it, it actually has indications that there has been a fair amount of communication at the technical professional level, because this is the kind of thing that should be totally apart from party and politics, et cetera. It should be really an issue of the expertise in the executive branch and the expertise on the committees, ledge councils, and so on that are working out language that makes it more possible for the executive branch to implement. But that's still a ways away. I mean, this is the first beginning of the bill, and ultimately that kind of thing can be refined. But I think there are signs of it in the bill, and so I'm heartened by seeing that. On the big issues, let me just pick out a couple of them, because there are many, many that one could pick out. This is such a huge bill at this point. But let's take one big issue that the Congresswoman has raised, this question of security and the possible triggers, and the focus on the border and border security as part of that, although the triggers are both border security and an employer verification system being in place, as well as an exit system being in place to combine with the entry system that was, they were both mandated after 9/11, but the exit system hasn't been put into place. So on the border security part of this, I think that there's a bit of a sigh of relief right now about that design, because it could have been a set of really hefty moving of the goalposts that would be, extremely difficult to meet, and in fact would serve as a way of frustrating the rest of the bill. And that's not the way it's written right now, at least as I see it.
I agree.
And that's a very hopeful sign. That, to me, says that there's been a lot of conversation going on between DHS and particularly the Border Patrol, and probably Senator McCain's staff. I mean, that's my guess. Because the way in which that border security language is written right now is really, I think, eminently doable. In my own opinion, it's disproportionate, the amount of money that's being talked about for border enforcement given where we are on the border, but that's not the issue. It's a political issue. It's the price of entry for the whole bill at this point for the Republicans. So we just have to accept that fact. And a lot of money is going to be spent, if this survives in the way that it is, on border security issues in ways that I think could be spent more effectively on other elements of enforcement. But even so, I think it's a given. The things that are being asked, the executive branch can do. They're asking for plans for better security. They're asking for plans for more fencing, even in terms of 5 years down the road or 10 years down the road, what has to be demonstrated in order to open the door for adjustment to permanent residents, are having them largely implemented, largely deployed. I mean, those are things that the executive branch can work with. And this other issue of a 90% effectiveness rate is something, amazingly, that because of the way the definitions have been written on how that would be determined, the Border Patrol feels it can meet, and can meet in these high-risk areas rather than entirely across the border. I mean, it's very, very in its own way, kind of elegantly pulled together in terms of the way the language is. So I think that, that works. Then you get the issue of legalization, which is a huge, huge endeavor for the executive branch to pull off under any circumstances. And let me just give you the sort of proportionality here. Let's say we have indeed 9 to 10 million people, and I'm saying 9 to 10 just to be a little under 11 million for one reason or another in terms of who's likely to come forward, et cetera. So that's just 10 million people. I believe, it's been a little while since I've checked this, but I believe that 5 million is the largest number of adjudications total for all of the categories of petitions that the USCIS has ever done in 1 year. So you're now talking about double that for just one new category of applications, in addition to all the rest of the work, of course, that it has. This is a huge, huge scaling up that needs to take place. But it is doable, much more doable now than it would have been 10 years ago, because of an enormous amount of investment that has been made in data systems and in data interoperability. So that the key issue from the get-go, which is the background check, and being able to receive applications and go through a background check, is possible today, and the infrastructure of application support centers that is in place for USCIS, and the fact that you can electronically take fingerprints. These technologies now that are completely familiar to us lend themselves to being scaled up in a way that would be required for this program. The very best thing about the way the legalization program is written at this point is that it is largely prospective, which means that the first step is a simple registration step rather than a full adjudication for lawful permanent residence. So from an administrative standpoint, that makes it much more doable, and we should have confidence, I think, that the executive branch will begin to be able to pull this off if the funding mechanism is put into place that allows for major upfront investment in the hiring and the scaling up, not simply waiting for the fees to come in, because if you've got to wait for the fees to come in, then you can't do the huge, big leap forward that's necessary to put this into place. There are lots of other things we could talk about in terms of the way the bill is currently drafted that have to do with implementation, but those give you some indications.
So, Tino, as somebody, your name is very well known inside the Beltway as somebody that's looking at these things, thinking really intelligently about these things, but you are an outside the Beltway guy. How does this look from your perspective in terms of, did it meet your expectations about getting close to the policy solutions that we need? Are inside the Beltway, are they navigating the politics and the policy of this in a way that makes sense from where you sit?
Thank you, and I'm very honored to be on the panel. I will tell you that from outside the Beltway, how does the bill look? The bill looks, is what I would say. And I mean, the truth is, I think what is most important about this is that it signals that we have a historic opportunity as a country to do the right thing. And what exactly it means to do the right thing is, of course, part of what needs to be further debated and discussed. But fundamentally, I feel like it signals that we have an extraordinary opportunity. We've never been closer to comprehensive immigration reform in a generation, and I think that matters a great deal. I do want to highlight 4 things that I would bear in mind, and particularly to tie that to domestic enforcement, and specifically to employer verification, because I think that's an important part of this discussion. And while it is getting some attention, and certainly it's a well-known subject to people in this room, it probably isn't getting as much attention as it will need in the coming days. My first point is that change is coming. I think it is most likely that change will come through changed legislation, but make no mistake, the equilibrium, the situation we have right now with respect to domestic enforcement of immigration laws, I would characterize as being highly unstable, because it is one involving high enforcement, mixed compliance, and high public frustration. And to my mind, that's a recipe for change. It means that something is going to have to give over time. Either the expectations of the public will change, or enforcement will ramp up even more, or pressure will build for something, even in the absence of some more comprehensive solution. So is it better for that change to come in the context of a more comprehensive discussion of immigration? Yes, that's my position, but I would insist that change is likely to come one way or the other. Second, the politics of all immigration issues, but certainly this is true of employer verification, are what I would characterize as being very non-boring, by which I mean unpredictable and not lining up to conventional partisan divides. To illustrate this, I want to say a word or two about the politics of crime over the last 40 or 50 years. It's hard to explain the rise of the modern Republican Party nationwide without thinking about the role that the rhetoric and the reality of concerns about law and order have played. So if you look at the Nixon campaign, if you look at the way politics play out in Congress, this has been a very, very big issue. And the politics of criminal justice and law and order are not disconnected to the politics of immigration enforcement, as I think we've seen for many decades. But it's also important to note that for Democrats, law and order, criminal justice, that has become a very important issue as well. And at least since the early Clinton administration, Democrats have owned the law enforcement issue almost as much as Republicans have. And I think if you want to understand the politics of immigration legislation, you have to take into account that fact. Now, what this means is that from a law and order perspective, you have Democrats and Republicans who are going to be pushing for mandatory employment verification. But you also have, on the left and the right, folks that are going to be very concerned about what employer verification can mean, or maybe needs to mean if it's going to be mandatory, which is to say a very new role for the federal government, one that involves the monitoring and, certainly if you frame it one way, the approval of employment relationships. So that's something that whether you're a member of the Tea Party or whether you're concerned about civil rights and civil liberties, it's not something that is easy to accept, even if ultimately it's something that people will get used to and people will understand has its value. And then last, but certainly not least, among folks on the left, you're going to see, I think, a split between those who think that immigration reform is so important, so critical for the nation and for its people, that accepting some big changes in employment verification are necessary. And then you're going to see a contrast with folks who think that immigration reform might be important, but that the real issue here is ultimately what is the role of the federal government? What does that mean for the future of America? I think we can nonetheless navigate that. By we, I mean the nation. I think the needle can be thread, but it's complicated. Third, due process matters. So very briefly, I'll just note that the issues that are going to surround employment verification are going to be heavily about constitutional due process, both procedural and substantive, and happy to talk about this more. So on the procedural front, certainly the question is going to be, what process is due to somebody who's told, you might think you're an American, but you have not proved that to the satisfaction of the federal government, and if you want to work legally, you've got a problem. What kind of hearing is that person going to get? What documents are going to be at issue? What evidence is going to be admitted? Is there going to be judicial review? I think it would be a stretch not to expect that there would also, though, be litigation that would be about substantive due process. The idea would be advanced that the liberty interest that Americans have includes the right to work, and questions might arise if you get to a system where people are told the choice that you have made not to comply with laws from the federal government to show that you are legal and able to work means that you're not entitled to work. So if you want to think of this in terms of the Senate bill, I would just note the provision that applies as a sort of catch-all that says, well, if you don't have a passport and if you're not from a state that has agreed to share the picture in your driver license with CIS and with the federal government, DHS will figure out a system for adjudicating that kind of stuff. Well, that's where a lot of the action is going to be, and I would note that that will have to be drafted very carefully and implemented very carefully to avoid some of these due process problems. Last but not least, to echo Doris's point about legalization, a similarly vast implementation challenge will loom involving the adjudication and processing of employer verification queries. This is a very, very big thing, and certainly it will involve administrative talent and leadership. It will involve the need for substantial resources. It will involve the need for patience. It will involve some creativity. I think it can be done, and I think ultimately on the success of it rides to some degree the possibility of immigration reform not only succeeding as legislation, but as a practical program. If we don't get it right, I think we are risking a repeat of the frustration people have felt with IRCA. If we do get it right, I think the impact is going to be very long-term and positive and might actually show the rest of the world what it means to be a free country that cares about the law, but that is very welcoming to immigrants and that is very thoughtful of the different needs and concerns and rights of people around the country.
That's, you know, when you talk, I come from Arizona, the land of black helicopters, and on some issues, you're right, you know, politics is not a continuum straight line, it's circular, and if you go far enough right, you're left on some of these issues around privacy. So I think it will be very interesting to see how those privacy issues, due process issues, you know, play out in all of this. And, you know, Paul, you're going to get us into the meat of what some of this bill says around these issues, but Ms. Lofgren, I know we may lose you, so I wanted to come back. What do you think of this assessment, or any sort of thoughts about what's been raised by Tino and Doris?
I think it's true, and I will say that there has been communication between the administration and various elements of the bureaucracy so that we understand both the constraints but also the resource requirements of standing up some of these provisions. In terms of E-Verify, if you look right now, we have a voluntary E-Verify program that has, you know, millions of people involved in it, but to ramp it up, you can't do that overnight. I mean, it's a multi-year process. It's expensive both in terms of the Social Security Administration as well as DHS. There does have to be, I mean, there's an error rate that's getting better, but, you know, we were talking about Americans. I mean, there has to be a capacity to preclude people from being disallowed to work. I mean, that's a huge issue. And, but it's interesting, I've not yet seen, for the most part, resistance. I mean, I sort of led the fight against E-Verify on the committee when the idea was to do E-Verify without immigration reform, and you're just doubling down on a completely dysfunctional system. But it's interesting that both Jeff Flake and John McCain from Arizona are on board on this, and Senator Rubio is a Tea Party guy. He's on board on this. So the voices that you're outlining, what I used to think of as the Black Helicopter Caucus, has not yet been heard from. And in fact, they're looking at the enforcement issues because they're hearing from the political right about the need for enforcement. So we'll see what happens. I wish I could stay longer. I do think that if the House bill gets done, which is not a guarantee, it's not going to be exactly the same as the Senate bill, but I will say there's a strong interest in making sure that what's been provided will work, because you wouldn't work for 4.5 years to do something to not have it work. And with that, thank you for letting me participate.
Paul, take us into the meat of what we know or think we know about in this particular issue, some of the enforcement, worksite enforcement issues, so that we can begin to look at them in detail.
That's good, Ben. Thanks so much. And again, I'm happy to be here. It's my third year at the Stanford Symposium, so I really enjoyed being out here. Maybe just a few general comments before getting into the worksite enforcement, and which is sort of the focus of the symposium. First of all, in talking about the history of immigration legislation any number of times in rubber chicken speeches and things like that, I've always made the point that meaningful immigration legislation is never passed in an odd year. The one exception being the elimination of the quotas in 1965. And the reason for that, the significance, if you live outside the Beltway, if you live inside the Beltway, of course you know exactly what the significance is. Odd year is the first year of the Congress. The even year is the second year of the Congress. And these things have to percolate for virtually the entire 2 years of the congressional session. And it's typically the last thing that happens before they turn the lights out. And that's what happened in '86. It's what happened in '96, and a lot of other legislation. So sort of my own view is next year would be a perfect year for immigration reform, because I think we'll have to have some debate. There's going to be a lot of debate on it, but I'm hopeful that we're going to have meaningful legislation in that time. I did have a question, Doris, about you very rightly pointed to the fact that the Senate bill talks about money up front for implementing, some of the triggers, of course, at the border, and also having some upfront funding for the legalization program, if you will, or the registered provisional immigrant program. But those are all authorization, and so we haven't had an appropriations bill for. I just can't even. I think it was before I was still in high school when we had just kidding. But that has to be. It's got to be very important to actually implementing something like this. Is their the congressional willingness to appropriate funds to do this up front?
It's funny, we were having this conversation yesterday at another meeting that most of us were participating in, because the summary language, and I think even some of the bill language, uses the word appropriate. And I kept thinking, these are mistakes. They've got to be talking authorization because that's all they can do. But apparently there actually is, there are some bills and some procedures in which the authorizing committee actually can lock in appropriations. Now, I don't think that can be, into the future forever, but this may be a more muscular approach that, they may actually be using the word appropriate properly given rules and procedural vehicles that are available to them. Sure. So there does seem to be a recognition that the money part of this is, is a critical element.
Excellent. I'm sorry you missed that discussion.
No,
that's
I'm
great.
not. I want to check further on it,
that's
but
good
it
news.
seems that this was explicitly.
We're going to actually get money out of it.
Yeah.
That's great news. One of the other sort of just general observations about the Senate bill is it's very, very detailed, and Ms. Lofgren made reference to it. Doris made reference to it as well. So detailed that in places it really looks like regulatory language. And I think that is probably purposeful. I suspect, although as a former regulator, I sort of bristle at the idea that Congress is getting into, what should be left to the executive. But I think it's your comments that this bill really reflects a thoughtful discussion between the Hill and the executive branch on some of these issues like data privacy and some things that weren't dealt with in the 1986 Act. And given the current atmosphere, at least with respect to Department of Homeland Security, State Department, Labor Department, and their sort of seeming inability to publish regulations for public notice and comment, I think it's probably a good thing that we're leaving just precious little to the administration to define in terms. There's plenty of regulatory work that needs to be done. It's certainly not a self-executing bill as it rolls off the Hill, but I'm heartened by the fact that it's almost self-executing, if you will. So we'll see.
Okay, now I just have to jump in here.
Yeah.
I have to jump in here to just say that Paul can be particularly an acute commenter on regulations because we were, of course, at INS together in the 1990s, and Paul was the general counsel at the time that the 96 laws passed, and we put him in charge of the task force that wrote all the regs for the 96 laws, which was 80 regs, 80 separate regs. Wow. In 6 months?
In 6 months, right.
Exactly. So if anybody knows about, and we obviously were able to publish them because we only had one department to go through, which was the Justice Department directly to OMB, as compared to the issues now. So you're listening to the expert on the issue of legislation and writing regs, and you all did just an incredible job.
Your hair was brown back then.
Hey, my hair was definitely it was brown, no question.
There was a price to be paid for your success.
Exactly. The other sort of general comment is before the worksite enforcement is just in terms of the elimination of the diversity lottery. Mrs. Lofgren talked about needing to develop some approach that will keep diversity in the system, especially given the percentages that she talked about, which I was surprised by, of diversity lottery cases coming from Africa. There will be debate, and I'm not sure how the bill deals with it because I haven't gotten to those pages yet, but there has been some discussion about eliminating the per-country caps, and at least on the employment side, which I spent a lot of time paying attention to, that would, eliminating those per-country caps would make the whole process an India and China process for the employment-based categories. And maybe that's right. You know, I don't know. I mean, there's a certain sense of, you know, it should be a first-come, first-served basis and not depend on where a person is from. But if we're doing that at the same time as eliminating the diversity lottery program, it's really going to have a significant effect on diversity. And so by eliminating that, it really puts more of an emphasis on the per-country caps and exactly how to deal with that issue. I'm sure I have plenty of other comments, but why don't we talk about worksite enforcement, which is what we're here to do. The sausage reference, of course, is the fact that neither the sausage making process nor the legislative making process is very pretty when seen in person. So that's the reference there. These are just a few of the points that I wanted to make in terms of the worksite enforcement efforts. And let me actually get back up to that page. Some of the key issues that were dealt with by Congress during IRCA in 1986, the legislative back and forth in terms of the decision making, and then bringing us up to date in terms of the Gang of Eight bill, and some questions, not necessarily answers, but some questions that are raised by the legislation in terms of worksite enforcement. What were some of the key issues that were dealt with, at least on the worksite enforcement? As we know, in '86, we had two different legalization programs. One was for people who had been here unlawfully in the United States since prior to 1982, and that their unlawful presence was known to the government, the language that I never want to see in a bill again for as long as I live. But some other ones like that are in this bill, like brief, casual, and innocent departures, are going to be are going to have a significant effect on how these cases are adjudicated as well. I would just as soon see that provision amended as well. And so we had the legalization program for people who had been here since prior to 1982, and also a special agricultural worker program for people who were working in agriculture for a period of time. And Senator Simpson at the time, and I have to mention Senator Simpson because I'm filling in on this panel for Carl Hampe, who was his counsel at the time of the 1986 and 1990 acts, actually. Senator Simpson talked about it in terms of a three-legged stool. You have improving and increasing the security at the border. He talked about it in terms of closing the door, closing the back door, an employer sanctions provision that penalized employers for hiring undocumented workers, and then a humanitarian effort to legalize. I think we had about 6 million were the estimates of in 1986. Legalized some 6 million people who were here out of status, and all three of those were intended to work together. None of them worked perfectly, and certainly the ambition that all three of them working together would stem the flow of illegal immigration was just simply didn't work. And one of the reasons for that, at least on the worksite enforcement side, was worksite enforcement was never really funded by Congress. We just had to sort of make do with the funds that we had and apply worksite enforcement along with other priorities such as fraud, removal of criminal aliens, and other activities that didn't leave a whole lot of funding for worksite enforcement. And so it wasn't really until much later in the 2006 administration when 2006 in the Bush administration when we really started to see efforts to step up worksite enforcement and both criminal and civil sanctions in large numbers under the employer sanctions provisions. few questions that were being dealt with by Congress. Were the civil employer sanctions penalties supposed to either supplement or supersede the Texas Proviso? I'll talk about what that is in just a minute. What to do with the Texas Proviso and what type of a verification system should we have? I forgot that this is not changing mine. So Congress wrestled with the issue, and what they ultimately decided was that the civil and criminal penalties under the employer sanctions provisions under Section 274A without the parens, I don't know why they put these sections right back to back, but they did, would supplement the existing criminal penalties under Section 274 parens A close parens, which is a completely different section of the law, had preceded the 1986 Act, and it's basically the alien smuggling provisions, the criminal provisions for alien smuggling. The Texas Proviso had been in place to say that employment, and it had been in place for many, many years before 1986, that employment does not constitute harboring under Section 274A. And so by eliminating the Texas Proviso and not making employer sanctions the exclusive penalty for hiring undocumented workers, left open that opportunity for U.S. attorneys' offices to prosecute employers under both employer sanctions 274A and under the anti-smuggling provisions, under the harboring provisions of the anti-smuggling law. Congress recognized that a secure verification was the key to effective employer sanctions. There was no political support for a national ID card. In fact, the legislation specifically said nothing in this law shall be construed as authorizing the establishment of a national identification card. Not really more political support for more secure documents or databases at that time. And we didn't have the technology available to us today that we have today to even imagine having a mandatory e-verify system where employers are required to run checks against the documents that are being provided to them. A couple of things that happened that I'm not sure we were really ready for. One was the employer sanctions provisions put a premium on the Immigration Service, INS at that time, turning around work authorization applications in a timely manner. I think we were a bit taken by surprise of the demand created by that, and I'm not sure we ever really recovered because we're still not timely getting employment authorization documents from the agency, depending on your timely enough for employees who are or should be work authorized to have documentation of that fact. And just as the I-9 verification spawned a cottage industry in the production of more sophisticated fraudulent documents, E-Verify now, as we know, has introduced identity theft as the next stage of unlawful activity. And what's really taken what was, in 1986, 87, you could buy fraudulent document packages for about $70 on the street, $70 to $100. Now, an identity theft package costs about $1,200 to $1,500. So it's really increased the price of doing business there. And the Gang of Eight legislation recognizes this. What ICE has imposed on us, I should say us, but on our clients as employers, is not just verification under I-9, but also and E-Verify, but also having a system in place that an employer will identify duplicate use of Social Security numbers and have a system for addressing that. The new the draft bill has a provision specifically in the statute that would expand that to the E-Verify database itself, so that we're not just imposing requirements against one individual employer who rehires somebody, but the entire employer community. So it really, if it works, would be dramatic in terms of identifying duplicate use of Social Security numbers, which is an indication of identity theft. So what does it do? The Senate Gang of 8 bill in terms of employer sanctions mandates E-Verify with the anti-identity theft enhancements. It preempts the state E-Verification laws. So I'm sorry. Oh, okay. Yeah, you why don't you do that? I can't do both at the same time. My wife tells me I can't do a lot of things at the same time. We'll eliminate the patchwork quilt that we have currently of different states having different laws with respect to E-Verify. Elaborate rules on the new mandatory use of E-Verify. E-Verify has, except with a couple exceptions, been voluntary in the past. Now employers are going to have a whole new set of rules. Not only do they need to review documents and complete I-9 forms, but they also need to deal with E-Verify certifications, responses coming from the government about tentative non-confirmation of employment or confirmation of employment, how to deal with the employee in circumstances where a negative answer comes back. So it's going to impose substantial new burdens on employers. New and increased penalties for pattern and practice violations of not just pattern and practice of employment, but also the system itself. And it phases this in. Within 2 years, employers of 5,000 or more employees will have to use the system. Within 3 years, employers of 500 or more employees. And then within 4 years, all employers in the U.S. will be required to use the system. There's also a 5-year provision for Indian tribes and employers within Indian tribes. You want to go to the next one there, Ben? So I guess the questions and not necessarily the answers here are, will small businesses revolt at what this means for them, the increased requirements of the E-Verify, the mandatory E-Verify system and the new penalties? Will the business community accept expanded Office of Special Counsel jurisdiction? We're going back to a strict liability rule, at least in the Senate bill, with respect to document practices. So if an employer requires a different or specific document than the one presented, today the government has to prove that there was an intention to discriminate. That would be eliminated the way it and go back. It's going back to the way it was when the 1986 Act was originally enacted. So a request for different documents will involve strict liability on the part of the employer. And then the big question is, will this legalization of 9 to 10 million people create enough of a pool of labor to address future flows, future needs of employers, and that's a big question. Typically, in the past, people who have legalized have moved up in terms of employment, and we'll have to see how that plays out in terms of this legislation.
Oh, excellent. All right. So I'm interested in your thoughts on all of this, but I do want to. Your comments about this being, almost ready to be, implemented, all of this spelled out in detail. From my perspective, that's one of the concerns that I have here is that Congress is, I think, in an effort to, to assess and drive these political issues, is making law much, much more complex than I think most of us would like it to be, and that really the implementing regulations, the enforcement issues are where we ought to be in the weeds and not so, we're just creating a statute now that's just going to be huge. And I think one of my concerns is in an effort to address a lot of these political points, Congress has to, sort of put their fingerprints on all of these pressure points in ways that I think is just, the statutes are notorious, not that this doesn't happen in a regulatory context, but statutes are notoriously difficult to figure out. We're just going to require courts and interpreting them rather than the sort of the flexibility and the give and take that you get in a regulatory context.
Well, it makes it more difficult to change too. I don't want to suggest that that's a good answer necessarily. Only that when I look at the agencies and how paralyzed they are in their rulemaking processes, I have some concerns that they can actually implement this in a timely manner if we're relying on regulation, substantial regulations. That was the point.
Yeah. So Doris, where do you, I mean, as he's laid out some of these things, what, as they say, what keeps you awake at night in terms of some of these worksite enforcement issues that Paul was talking about in this context?
Well, I share what you've said about too much complexity and too much detail in the statute. I mean, that's so evident with the immigration law now that our hands are tied on so many fronts on, you know, the broad issues, and then you get follow-up statutes that, you know, raise the number of H-1Bs for 3 years, and then it falls back again, and, you know, all this sort of thing. I mean, it is just so top-heavy. But Paul is also right. There is just no regulatory activity in a timely fashion coming out of the executive branch. I mean, the Department of Homeland Security is still, even though it's 10 years old, a new agency. It is not in any way an evolved government agency from the standpoint of the processes and culture, you know, within the agency that places like the Justice Department or the State Department that we, you know, have worked with in the past in terms of regulations would be.
Plus, Doris, if I could just add one point that you made earlier is, it's not only the creation of a new agency, it's also the split in authority.
But that's
over
what I mean.
immigration.
And
right.
so it's been, exactly. So you fragmented these functions, which in fact are organic functions, without then the bureaucratic, you know, sort of maturity and processes in place to overcome that. And that will really show itself. Now, sometimes those things get straightened out with more crisis, and a new bill, a new law that has to be implemented represents a crisis for executive branch agencies in terms of the, you know, pressures that are on them. And there are some things in the Senate language right now that are mandates for regulations within 6 months. And sometimes, though, that would actually be a better way to go, is to mandate regulations on some topics within time periods than to work them all out in the statute, because of exactly what you've said, Ben. These things have to change over the time, and they've got to be informed by experience. And if things are working, you know, effectively, or more effectively, some of the experience that is gained then can be incorporated in agency operations. And actually, I think the Verify program has shown itself to be among the more responsive programs that exists in the executive branch in the immigration arena. So, you know, I would hope that some of this detail does get flushed out, and maybe the difficulties of moving regulations be treated in the statute in different ways by setting timetables rather than working out all of the issues in the statute itself.
It's only been 4 days, but what keeps you up at night?
Well, I thought Paul's presentation was terrific, by the way, very, very helpful. And I think one of the things that kept me thinking about, which again echoes the point that Doris was making, is when the Department of Homeland Security was created, there was a very powerful assumption behind it, which is that if you create a cabinet agency around a set of functions, the agency structure can provide for coordination. And yet the irony, of course, is that for functions involving immigration, there was a corresponding fragmentation happening in two directions. One is not all the functions relevant to immigration were going to be in DHS at all. There were going to be some functions that rightly were going to stay at DOJ. There are some functions at DOL. I mean, even the Social Security Administration has a role vis-a-vis E-Verify. And then, even within DHS, immigration functions were fractured in quite different bureaus. And I want to express a great deal of admiration and appreciation for people who are very hardworking at DHS, and I had the chance to meet and to collaborate with many of them. But I must say that what was really revealing in the interagency process was that sometimes the gulf inside DHS between CIS, CBP, and ICE was greater than between the sort of folks running the departmental machinery of DHS and DOJ, for example, or between labor and DOJ, and so on. So that means that these issues of exactly how the regulations are going to be drafted are going to be more complex, and notwithstanding the fact that in some cases Congress has taken or may take a giant step in clarifying the details if something like the Gang of Eight proposal ends up being enacted in this form because of all the details that have been worked out here. There will still be this interagency process that will grow and that will create dispute around implementation. And the other thing I want to note is I do think it is right that E-Verify has gotten much better over time. I think, you know, for all the folks who have rightly been concerned about the error rate, it's a fact. The error rate is important to think about. It's going to be even more important to think about as it ramps up. It has gotten better. But I must say, I think that one of the toughest questions for any lawmaker is, or for any regulator, if the discretion is given to them about just how quickly to implement change, is just how fast can you go? This is a problem that I thought about a lot in the context of immigration, but also in the context of food safety, in the context of a public health bill that I worked on that expanded the functions of the FDA. And in all of those contexts, there was a striking parallel, which was you want the benefits to be worked out.
No, we can't hear you. Could you turn on your microphone?
You want the benefits to be achieved. You want people to talk into the microphone, but you also have to be aware that it's incredibly difficult, and that if implementation fails early on, it's very difficult to recover because then the agency has to redesign a policy when it's already going. So that keeps me up at night. Sorry.
So I wanted to. I don't know how much folks have had a chance to really dive into this, but I mean, look, we can all acknowledge there are bad actor employers out there, but some of my concerns in responding to the politics of that, we may have overreached in some instances, and some things jumped out at me, and I didn't get a chance to compare it to the existing statute or what it is that they're modifying, and I only brought a summary on the plane because I didn't want to have a carry-on bag known as the bill. But it says in here, there's some provisions in section 4222 and 4223 that sort of made me nervous. In the summary, it says, in all instances, employers, this is in the H-1B context, employers would be liable to H-1B workers for back wages and benefits. But actually, I did look at the statute in that context, and it said they would be liable to any employee for back wages and benefits, right? So empowering folks to, potentially disgruntled employees to bring causes of action against employers. And then 4223 says, eliminates the need for reasonable cause to suspect noncompliance to initiate an investigation, and also eliminates the provision that states that the Secretary shall personally certify that reasonable cause exists. The amendment would also permit complaints from anonymous sources and would allow DOL employees themselves to file complaints. Provision provides that a complaint must be filed within 24 months of an alleged incident, up from the current 12-month time frame. So I don't live in your all's world day to day. I mean, does that scare other folks? Are they really, particularly removing the need for reasonable cause to suspect non-compliance? Does this mean DOL's going to be able to initiate investigations just cause, not just reasonably cause?
Yeah, I don't. I have to go back and take a look at the language there. I'm not sure that that's an appreciable change from what we have today. But yeah, I mean, if it lowers the standard for investigation, then it certainly does. I think the back wages was sort of a housekeeping provision that if somebody's undocumented in the U.S., they're still entitled, and if they're entitled to back wages because they have FLSA or some other or H-1B obligations, that person is entitled to collect those back wages, notwithstanding the fact that they're out of status, but they can't be reinstated. And so the language that I saw, at least, was just making a clarification in terms of that.
Yeah, because apart from the language, I mean, one of the things that I'm worried about in the political process is going to be the ability to push back on the politics of the enforcement. Look, we've got to, if fraud is happening in some context, how are you going to know? We know that there have been problems in terms of the agency having the ability to really look at the right kinds of issues and follow up on potential wage violations. We know there have been some, I guess, legitimate complaints about some constraints, but my concern is that the politics of this issue and the timing of it, because I disagree. I think this is going to I think time is not our friend on this issue. I'm worried enough about this hanging out over an August recess, let alone, the big Christmas break and all of those kinds of things. I'd much rather see this move quickly, but whether it's quickly or slowly, I don't know how we're going to be able to push back on the politics of some of these enforcement issues.
But I will say, I think it's am I doing better on the mic? Okay, good. There are political questions, of course, that arise that people are concerned about too much enforcement. But if an increase in H-1Bs is going to be part of this bill, I have a hard time imagining how the politics would allow that to happen without some language addressing these issues. So then the question is, like, what is that language going to be? How is it going to be implemented? So,
well, I want to open it up for questions for folks to ask. I assume, Margaret?
Well, we're here at the Rock Center, so I guess I wanted to ask a big historical question. Because the Hoover Institution's right down the street, I think. And it struck me listening to you that prior to 1986, we didn't have any of this huge regulatory regime, and nobody could have written the book, that great book that Chuck and Marcine and Chris wrote. And we wouldn't have all these jobs for lawyers and regulators, because, the Republic hadn't fallen yet, but people weren't required to show that they were authorized to work. And I'm just wondering if anybody's done any big study, or maybe MPI has something coming saying that, this huge, big regime that we've built up since 1986, was it worth it? The costs, the benefits. We've gotten all this increased regulation, and I can tell you, because I represent a lot of small employers, they're going to rebel with E-Verify. That's just a fact. It's, the new I-9 forms, 21 minutes per employee. That's adding 10 minutes per employee when you hire somebody, and now you're going to have to train somebody on how to use E-Verify. And I'm sorry, it's not that easy to use. The government says it's really easy, but you got to invest, send an employee to the training. They got to keep getting updated. There's liability issues and all that sort of thing. So people are going to rebel. They're going to say, this is too much work. I can't deal with this. And I'm just wondering if somebody's looking at the big picture historically, cost-benefit analysis. We put this whole regime in place. Have we gotten a bang for the buck out of this? Is society somehow better off overall in terms of, overall social good, I guess, and problems that we have solved by creating this huge regulatory regime that's occupying lots of lawyers? Thanks.
Are you talking, Margaret, about the regime in terms of employment authorization verification?
Generally, no. Just, prior to 1986, you could just show up for work and start working. You didn't have to show anything, no ID, no proof that you were authorized to work in the United States. And granted, you could be deported if you were working without permission, if the government caught you.
Right. And
you were violating your visa status. But we didn't have this giant regulatory regime that, requires us to have a conference on worksite enforcement. We didn't have thousands of lawyers doing audits and compliance and all that sort of thing. So I'm just wondering, socially, are we better off? Has somebody done a study to figure out what the costs of this huge regime have been, and have the benefits been worth it?
It's an excellent question. I'm not aware of any study. The only indicator I have, as I pointed out, is that identity theft has increased because of E-Verify, and so that's at least an indicator that it's having an effect on how people gain employment in the United States, and it's making it more difficult for people who are unauthorized to be employed in the U.S. But it's a very good question, because the costs of the whole system, I don't even know how you get a handle on that in terms of what it's cost for employers to actually implement it.
Yeah, I'm not even just thinking of employers. I'm thinking of the fact that identity theft has skyrocketed. That's a cost of the system that's predictable. There's websites now that just sell people's names and social security numbers and dates of birth so that you can work. And you can go to an E-Verify employer with this information and get a job now, because you can get past the system. And that's a cost to all Americans. People are constantly having their identity stolen, not just because people want to buy credit cards now, but because people want to work. I think everybody knows about the LifeLock guy who put his social security number on billboards all over the country. And apparently lots of people got jobs. Thanks to him, he put his social security number in the airplane magazines and his name, and you could figure out his date of birth on the internet. So it was really easy to do that. And I'm just wondering, I mean, I guess if you haven't heard of it, it must not exist, but maybe MPI can.
Yeah, if Doris isn't studying it, nobody is. I mean, it is a good question. I guess you'd also want to ask that, as they say, what's the counterfactual, right? I mean, it was clear that, what precipitated the development of this was the sense that we weren't really doing a particularly good job of stopping people from working without authorization in the United States. And, what are the alternative regimes to be able to do that, right? If you're not figuring out some sort of, process of assessing work authorization, then are you at raids, right? Is that how you address the problem? So, I think it's a fair point and a good question, but I think as part of that, you'd also have to ask that alternative question is, if we didn't go down that road, what road would we have gone down to respond to that? And it also, for me, raises the question, I get how small business employers will be pushing back on E-Verify, but looking at it from a sort of a inside the beltway, political messaging strategy, the challenge is that, again, what's the alternative? It's very hard to be arguing, no, we like the paper route, or, to be against, figuring out fast electronic ways to assess work eligibility is a tough place to be, particularly for those of us who are talking about creating an immigration system that works for the 21st century, right? You just sort of naturally end up going towards electronic solutions to these kinds of things. So I think from a political perspective, I worry about, all right, well, what are the alternatives, that could be developed to address what E-Verify is designed to address, right? I don't want to be that lobbyist who's saying, no, let them, electronic is out, paper's coming back, right?
Well, the one alternative that Congress actually did consider and rejected in the 1986 Act was having employment verification be only an affirmative defense as opposed to being mandatory for employers, and they rejected that. So, that's an alternative. It certainly was rejected pretty early on in the process.
I think following up on that great question is also in that cost. Are there any consequences for employers or businesses have just decided, I can't operate in the United States with this system, and so I'll just go and operate abroad and import instead? And I think we've seen that over the years become more and more of an issue for a variety of different industries, and that would certainly be factored in as well. But I think sort of going to Ben's point on the political point of it, I think the employment verification train is way down the path. So I don't see that, derailing. What's unfortunate, though, is I think, sort of to Doris's point, with the level of statutory legislation, it's not as smart as we could be. And because it's not as smart as it could be, that's going to make it more difficult to go forward. There might be a more efficient single work authorization card like we use for WIC, and there's a swipe machine. That would completely reduce the need for all these lists of documents and different things. Or maybe there's a different way that it can run within the E-Verify system. But when it's statutorily that heavy in the detail, I think we're crippling ourselves in terms of really trying to get to a better place. And there's a lot of, I'm already seeing a lot of response to the verification language, the data mining assessment that's happening on the back side of it, and how the algorithms are being used to make determinations about who's misusing it and how they're misusing it, when there's really not analysis that goes with it. There's going to be a lot of assumptions made from that, and there's a lot of fear from that. There's lots and lots of fear from all these different levels of lowering the standard and more statutory investigations. I think if the small businesses really understand that, they'll really just say, okay, well, never mind, we'll just hire less people, or we'll go for it, because they just don't have those of us who are sophisticated still, rub our heads 15 times a day, say, what do you do with it? But I think that's a real political vulnerability that most people haven't really gotten through, and I think that could really be a wave pushback. But I just wish we were smarter in it. But again, if we want to get something passed, get it forward, move it, and then be amenable to tweaking it in a better way instead. But the internal security, my actual specific question on the internal security, do you think that this makes us safer internally? From
the whole bill itself? Mm-hmm. And one aspect I think that does is the registration for provisional immigrants, because it allows people to come forward and be identified and have documentation and be in the system, if you will, whereas today we have 9 to 10 million people. We don't know, necessarily who they are, we don't have any background information on those people. They're not able to get driver's licenses in large measures. So you have a lot of people driving around without driver's licenses, which is a security issue as well as just a liability issue. So I think just in general terms, security from that perspective, but I don't know.
Yeah, I agree. I mean, I would add to that. I think that the overall bill, and particularly the legalization and the registration, even the provisional registration, is a step in the direction of getting to a point where law enforcement can actually build more trust with immigrant communities. I think that's actually quite difficult, and there's been some good work documenting some of that when you have millions and millions of people who are undocumented who are trying to interact as little as possible with law enforcement. I think, every moving part in the bill, you can sort of ask the question, does this move us forward on security or not? But to my mind, the most important aspect of the bill with respect to long-term security is helping get to a point where law enforcement resources are focused on building trust with immigrant communities and going after people who most want to do us harm.
Thank you. Thanks.
Dr. K.R. Murthy. The presentation was very well done and very clear presentations. I like it. Mr. Virtue's presentation covered there are operational and technological issues for verification, e-verification and so on. Assume that someone coming from me, I can solve all those problems. How do we go about it? I can bring technological value, operational, whatever else it takes to do, to make sure there's no duplication, none of that. I solve the problem. Let's assume that now. How do we proceed? How do we make it happen so that it's good for the potential immigrants and our country here to solve the problem?
I'm not sure the answer to that, but I think what the Senate Gang of 8, at least, the answer that they're trying to give to that is improved biometrics in terms of verification.
We will take care of all of that. We will take care of all of it. That's our realm. We can handle any problem you give. We will solve. We have track record of solving most difficult problems other people said will not be able to be solved. That I can guarantee you. And I'm going to bring the best in the industry.
I don't think I understand the premise of the question. So you're saying if you're able to, if we start with the premise that we're able to do what?
You give me the boundary conditions, restate it, reformat it, any way you want it. We'll solve the problem. For good of the potential immigrants and the country's, making sure all the security issues and, homeland security issues and things like that, and making sure that the Americans get the job first and all those things, everything you want. Set of conditions, boundary conditions, done. Done deal. See, that's how we should think, rather than worrying about problems. How do we solve it? Are there people who can take the challenge and solve it? It doesn't have to be one person. That's me. It could be whoever it is. Assume that we can solve the problem. We have to solve the problem. Then we go forward.
I would just say, I think I agree. I think...
you see the way I'm looking at it?
I think so. I'll just say this. When I was talking about what I think it would take to implement this, and I talked about creativity and leadership, I guess I'm agreeing with the premise that more than just technology and money, you need
operations, whatever aspects you talk, cost, we will try to solve the problems. Because the idea is to make it happen for everyone. It's not like one side or the other side. Everyone has to win. If it is to be done, we define. We form a committee of experts like you guys, and the representative who was here, make a list of what is to be done, what are the minimal conditions, necessary conditions, sufficient conditions, boundary conditions, cost limits, implementation limits. We have to solve. That's the only way to do, rather than worrying about these problems may be there.
Thank you.
It's our job to solve. Okay, thank you.
Thank you. I wanted to address what Ms. Lofgren had referenced, and I'd like to get your reaction to a couple of things she said. She talked about basically a dysfunctional system, and if I understood her correctly, she's a numbers person, and she thought, excuse me, that the numbers didn't particularly add up realistically, that the Senate bill had a disproportionate number of people going through, and wondered where all those visa numbers were going to come from. Number one. The second part is sort of a reference to what Margaret Stock had made. She talked about the bureaucracy that had grown up around enforcing the IRCA laws. And my question to you would be, do you honestly think that the bureaucracy is going to go away? In other words, it looks like there's a whole other bureaucracy that was created since IRCA. You all were in the INS, now it's DHS. It's certainly a bigger agency, bigger bureaucracy, and some of the things that look like the compromise in this bill are a beefing up of CBP, you know, having a border security push to make the bill more attractive to get it passed through the Congress. I'd like your reaction to those themes, because I thought that Ms. Lofgren really had some excellent perspective.
Well, let me start. First on the question of the Senate bill and what it adds up to. We're working on that right now, and I'm not sure that we'll be able to do anything more than ranges, because there are a whole set of avenues for legal immigration, particularly labor market-based immigration. But then combine that with the changes that are proposed in family immigration gives you a combination of things where there are some ceilings, but in many areas there are not ceilings. Now, unleashing some of the immigration from ceilings is a very positive thing from the standpoint of the current backlogs, but more than that in ways that you know some of the artificialities with some of the current backlogs, in that they're actually blocked because of the countries, and therefore Mexico and the Philippines are at a huge disadvantage as compared to, I don't know, you know, France. And and so it is a positive impulse on the part of the Senate to try to take some of that artificiality and, you know, paralysis out of it. But this does add up to, in the Senate bill, an extraordinary addition of numbers of people coming to the country, particularly permanently. You know, it would have seemed from where we've been that there might have been a bit more emphasis on the continuum from temporary and quasi-temporary into permanent immigration, but they've really loaded a lot of new permanent immigration in, and then when you combine that with the legalization provision, which is a very generous provision, some people will disagree with the cutoff date, but really a cutoff date of effectively a year ago is hardly a harsh measure. And I do think that as that becomes known, there will be pushback on that. I mean, and where those visas are coming from is not simply the ending of the diversity lottery and the program and the siblings. They're just creating large pools of new visas. So now, you are already seeing the reaction from the predictable anti-immigrant groups that these are just taking jobs away from Americans, et cetera. But there's going to be a much more sophisticated response than that, because this is just highly open-ended. At the same time, it is an attempt to try to deal in a serious way, and there's some very sophisticated thinking in this proposal with the labor market issues for immigration to the future, and with the problems that we have at the present time of not having adequate ways to come to the country legally for labor market purposes across the skills spectrum. And so there's going to have to be a reconciliation of that. I couldn't tell from what the Congresswoman was saying whether she didn't give us any clues, I don't think, on how it is that the House people that are talking about this are dealing with that. She didn't even give us any clues on how they're thinking about these family immigration measures, where she's absolutely correct in saying that these are totally false promises. You're hanging on to a symbolic thing to say that siblings, you know, should have a preference. I actually think one of the very intelligent things that's being done in the Senate bill is getting rid of that sibling category and finding a way for people to get an advantage into a merit-based system that is actually meaningful as compared to this, you know, symbolism. So, you know, that is one of the reasons that this bill is going to take time. I mean, you know, Ben, you're right that of course we know politically it would be a good thing for it to move more quickly, but there is a lot of that kind of thing that needs to be better understood in order for us to have a, you know, better system going into the future. You know, as to the bigger question of the bureaucracy and so forth, you know, it is, of course, this is a hugely sweeping change that would happen, even if some of these things that we're talking about get pulled back. I mean, this is an immigration bill, and the way that this problem has built up and led to a dysfunctional system, this is built up over decades. It isn't just the mistakes of a couple of years or the changes of a couple of years in the nature of the economy, the demographics and aging, you know, phenomenon for us as a country, et cetera. So there will be more bureaucracy with this. But it is also interesting to me what just in the verification provision, for instance, is being done to look at the identity issue and link up with states and state driver's license systems. When you know, one of the things with the E-Verify system and employer verification that I didn't say when Margaret asked her question is that an awful lot of what's going on in employer verification from the get-go is a workaround to a core value that we have as a society, which is that we will not allow ourselves to have a national identifier. We just won't. And even now that we won't for voting purposes, which is quite inexplicable to any other country in the world, and we won't even now that we're so much technologically based that it is possible post 9/11 rationale, et cetera. And you see again in this bill, we won't. Senator Schumer has tried to take this issue to that point in saying that Americans will really believe in the government's willingness to enforce the law if we all carry a card. He's again been pushed back in that impulse. I'm not making a judgment whether it's a good impulse or a bad impulse, but it's been driven out both by that value that we won't have a single card and a single identifier, and by the cost of it, because it was raised again earlier in the last several months in this debate, and it is simply cost prohibitive now from a fiscal standpoint. So therefore, you've got to find other ways around it. And these other ways around it, which are in the bill, biographics as one way of dealing with it, state driver's licenses where states have the sophisticated biometric quality kind of system of photographs, and so let's have the federal government work with states and pay them for some of that, as well as some other improvements. That's the price that we pay for not being willing to go with a national identifier. Well, those are choices we make, and those are values that are deeply, deeply embedded in the way that we do immigration. And to me, the interesting thing about this complex of things that the bill is suggesting for employer verification and dealing with it is fascinating in that it is looking to states in the classic way that we do in our democracy to be the places from which new ideas come forward and which then ultimately become sort of socialized politically in a way that they become a national norm. This is entirely different from Real ID, which in the middle of the 2000s says to states, thou shalt, and it is an unfunded mandate that we will not pay for. It now is saying, states, you really have come along in improving data repositories through the driver's license systems that have come about for reasons that are essential to your functioning effectively as states. And we now, federal government, want to encourage that and tap into it. Well, I mean, that's a tried and true way in which our democracy tends to function and is, working on this workaround of not having a national identifier. So I think it's actually quite American.
Peggy?
Well, it's very interesting that you came around to that point because it kind of goes to my comment question for you. Because we talked about the implications for U.S. citizens, the mandatory system, we don't call it E-Verify anymore, at least when we're talking about the bill, the new mandatory system and how it will impact on U.S. citizens who get non-confirmations and what percentage of the population are going to be affected by that as we go through this process of trying to get it across the board for all employers. And it really, you do get the politics of left meets right. And while we're saying there's no national ID, if there's a tamper-proof Social Security card that is the only way you can get work, we're getting closer and closer to the concept of a national ID. And so for those people who are, libertarians who don't want the government in their business, or civil rights, voting rights people that don't want to have an ID to vote, I mean, you have to have something to work, and you have to work. For most part, you have to work. So I see the politics there problematic, notwithstanding the fact that it states that we don't have a national ID. Ultimately, if you have to have your information in a database and a card that will allow you to work, I mean, there are going to be, I don't know what percentage of our American population are going to be affected by inability to present the right documents or to be confirmed in the database, but there will be some percentage. So I see that as being a problem with the mandatory across the board. On the other hand, I see the idea of the national ID, and I'll just make this comment. Our generation hates the national ID. I mean, we grew up with the Iron Curtain, et cetera. We don't want the government to have an ID for us. But my kids, their life is public to the whole world on Facebook, et cetera. And what's the difference? I mean, so it could be a generational thing that we move away from. And the concept of a voluntary ID. Now, I just got my global entry card. I am going to give them my biometrics if it means I don't have to wait in a line. And so the fact is, if it's easier to get a job, if you have some special ID, people may step up over time, and the whole idea could be diffused eventually. So.
Yeah, I had that experience. We took a trip recently with my family, and I stood on principle about being opposed to putting my name in the database. I stood on principle in the back of a very long line while my wife went through TSA check.
Stood in line on
and waved at me on the other side with a coffee in her hand. It's like,
back of the line.
Yeah.
One thing that's funny about
one comment on that, Ben, if I might. Has anybody done the Social Security self-check? You go on, do this. Did you get a positive response? I mean, oh, sorry, Sharon, you're fired.
Yeah, I think that statement, though, in the law, I almost, go ahead, sorry.
I was just going to suggest that we might already have a national ID card.
Yeah.
Well, but that's the point. But in name only,
It's kind of like it's like the SB 1070 law. Nothing in here shall be authorizing racial profiling. It's like, well, if you say it, does that really make it so? I mean, to say in the bill that nothing creates a national ID card, but also creates this
But that's how we
permanent Social
solve
Security
problems.
number.
I mean, that's what I mean by a
right.
workaround. If you can't go directly at it, which has been impossible, then you've got to go at it some other ways. If you believe that the jobs as an key element of illegal immigration is the correct analysis. And I've never seen any other. Otherwise, you can go the way of making life, I mean, there are two choices here in terms of illegal immigration. You either take the choice which really was represented by Prop 187, and you know that well in California. That was the fork in the road choice. Make life so miserable for people across the board that they will, and then that brings you to self-deport. That's the 20-year road of that argument. Or the best intervention point is the job. That is why people are coming. Therefore, you need border controls as well as an intervention at the workplace to be sure that a norm of working legally in the country is a new workplace standard. Those are the choices. And if you do the workplace part of it, you have to, that then opens this discussion.
And look, I just want to add one quick footnote to that. This is a great discussion. I do think it's a really important point to recognize that in a whole bunch of different ways we're maybe moving more towards a direction where that kind of employer verification can happen. I, for one, think there is still a distinction, though, between a national ID and even what is in this Senate bill. And I think there is a needle that needs to be threaded, but I think it maybe can be done. And I think that a lot will depend, apropos of the regulators who are on this panel, on exactly how an agency like DHS thinks through the question of what do you do in a situation where someone doesn't have a passport, doesn't have the driver license from a state that has complied with the photo tool. And there's some room there, I think, for some careful thinking about exactly how you come up with an American solution. And I think Doris's point about the states and how important they are in the system is a key part of that.
Well, thank you all very much. We are just a couple of minutes past, but thank you very much for a great panel. Made my job very easy.